When I asked the ICRC to help organize this, I said, we need a wow speaker to conclude the conference. And we know that all of you have been here since 8:30 in the morning, and I'm very amazed at your stamina, and you're going to be rewarded for staying. Pete is the head of the ICRC's unit for relations with armed carriers. And that doesn't sound as exciting maybe as his career has been, but you're going to find out in a few minutes how exciting he is. Pete, floor is yours.
There you go, no pressure, right? Professor Schaft, colleagues, firstly, let me thank Mike and your team really for the chance to join these discussions, to Case Western, to Cox International Law Centre, because the last few days for me have been particularly stimulating to hear all these different perspectives from a group of people who clearly care deeply about the future of IHL. I'm also drawn to reflect on how the discussions here mirrored discussions I had in Beijing at the Xiangshan Forum only about 10 days ago, 2 weeks ago. The Xiangshan Forum is a global security forum which is hosted in Beijing, draws in about 80 countries, includes Russia, India, Pakistan, Iran, as well as China, and a load of countries from the global south. And they were all talking about very similar issues to what you've been focusing on these last couple of days. So my takeaway is that these issues are of global interest, global importance, and that scholars and practitioners around the world are reflecting on both the benefits and the challenges of IHL on this 75th anniversary. I'm not a lawyer like Colonel Pettis, and so you'd be within your rights to think, well, you know, why is this guy making the closing remarks? Mike introduced me as the head of a team working with, on behalf of the ICRC, arms carriers worldwide. It's a team of around 40 former military, former law enforcement officers specifically employed by the ICRC to support our engagements with armed forces, with law enforcement agencies, and with non-state armed groups, coming back to one of our panel discussions earlier on. The ICRC is unique in having that capability, which gives us the capacity to engage what we refer to as arms carriers in a peer-to-peer approach, military to military, if you like, either to support their efforts to integrate IHL into their doctrine, their education, training and sanctions, or when we're raising protection concerns to ensure that they're backed by a proper analysis of the causes and the specific issues behind them. Having that capability in the ICRC means that when we're looking at potential IHL violations, we can look with solid, experienced eyes from both sides of the military necessity versus humanitarian impact equation. And I'm going to keep coming back to that. And of course, reflecting on our neutral, impartial way of working, we will also be having those conversations with both states and the non-state armed groups that was subject of one of the panels earlier. So I think the value I can bring to you effectively at the end of your deliberations is to share some thoughts from, if you like, a practitioner perspective, and thereby to draw some attention back to the purpose of the law and to look forward from that basis. So I want to start by a short story, and then I'll turn to some reflections from which I would like you to leave this conference with. So to start with then, a little story, because people remember stories more than they remember anything else, right? So I want you to imagine a small group of less than 100 young men, young women in a foreign country, long way from home, in the middle of a strange war, on a mission to detain some very specific individuals that some intelligence somewhere had said were very important. And they get on helicopters and they fly from one end of the country to the other, way away from their friends, to strike a target where the only support they would have was the weapons and the ammunition they carried, plus 18 fully loaded aircraft going around in circles for them just to support their operation because of the risk involved. This group lands in some dusty fields, secure their target, which was a large compound on the edge of a small village, and then settled in to defend it while the exploitation phase went on. In the midst of all this activity, an old goat herd comes walking through with a flock, through a bunch of young men laying on the floor, weapons loaded, fingers on triggers, and just walks straight through. The radio message become increasingly intense. What do we do about this guy? Seeking clarification. And in the end, nothing happens. The guy walks through and goes on his way. A few minutes later, these same soldiers come under fire from the village. Heavy fire. They begin to take casualties. They begin to take wounded. Machine gun rounds, anti-tank grenades. Young men sustaining life-sustaining injuries, life-changing injuries. Company medics running around trying to keep these people together. People are dying. The officer in charge knows every one of the men who's been killed or injured. He knows their girlfriends. He's written to their families for the last several months. The light weapons in this small force are not enough to change the balance, to stop the incoming fire. For the commander now, everything hinges on stopping this firing to protect men he loves. He decides to call in the air support to stop the firing from the village. And in doing so, he destroys the small group of mud-built homes and kills some 40 local civilians, many of whom had no idea of what was going on. Was that the right decision? Was that the right decision? Was that a proportionate response to that situation? Did the military necessity outweigh the civilian harm? And was that individual commander in the middle of that situation best placed to resolve what you know as complex legal and moral issues? Now, the story has a happy ending, right? It wasn't all true. I was the company commander, so it was my shout. But we did detain the targets we needed. There was no ill treatment in the field interrogation that we did in the compound. We did have that goat herd who walked through this chaos. I have no idea what the guy was thinking, right? There were weapons everywhere, and he just toddled through. Life is strange sometimes. The only bit I made up was the final element. We weren't attacked from the village, okay? I did not bring in the combined weapon loads of 18 aircraft with all the devastation that would have caused. My fear, though, is that in the circumstances described, with my Marines being killed, I might have, if I didn't have IHL as a core part of our whole way of operating, right? If you didn't have that way of stopping things. And the lesson is that we have to have IHL as a practical tool to be used by those fighting wars. Because at that point in time, that is the reflex you come back to. And if we don't have it, how do you know what is going to frame the protection of civilians? How are we going to make sure that there is a limit on the use of force? So coming back to our discussions, I think we've always have to be conscious that the law is a vital tool to help control the application of force in those desperately difficult situations which arise in warfare. We need the law to provide us with guardrails that will ensure we make the right decisions in balancing military necessity, and the law accepts military necessity, right? It's not a pacifist tool. But we have to balance that against humanity in the most ambiguous circumstances. And we need the systems in place to ensure that complying with the law is a reflex at the level of states, at the level of military commanders, and at the level of individual soldiers, which Laurie reminded us of earlier on in the day. Individual soldiers pull triggers, right? So that's the frame for the rest of my comments, if you like. Now, of course, as we heard in the last session, or the session before last, that the trigger for developing the 1929 conventions into the Geneva Conventions that we know now and the IHL framework we have, the 1949 conventions, was the desperate civilian harm caused during the Second World War. I want to use the rest of these remarks to touch on some of the points you have raised about challenges to the application of the law and where it may need to be developed. But we need first to recognize what that body of law has achieved. I know many of you, as I look around, have spent a career studying and teaching IHL. As a former user of it, if you like, I recognize that everything that we did on operations was shaped by IHL. That's not to say that we were perfect, okay? Please don't think that. In that small group of men that I took on that operation, included one man who would go on later to commit a war crime, okay? He was tried and convicted in a court of law, and he served his punishment, right? So in general, what we did during that operation and elsewhere was we did treat detainees humanely. We did our best to avoid civilian harm. We didn't use weapons that were prohibited by the law. We did all of that because that was what was pushed into us, trained into us. It was compliance with the law built into our doctrine, built into our education, built into our training processes, all the way from the top to the bottom, and then backed up with a sanctions system, right? So that Royal Marine who committed a war crime was tried and he was prosecuted, right? That's no small achievement. And in the last 75 years, I would say we have witnessed enormous efforts to refine and develop the application of the checks and balances that are in the law at the military operational level. This is a real achievement, and I commend all of those who work on IHL for the impact that you've had, because that is a real impact and has changed how the military fights wars. I don't want to paint an overly rosy picture, right? But in the frame of the conversation, it's important to look at the successes that IHL, both the Geneva Conventions framework and the wider regime of IHL treaties, have had. Despite the tensions of the Cold War and the rhetoric of the past few years and the last few days, really, the use of nuclear weapons remains a taboo. The same can be said of chemical and biological weapons. When we note that when these have been used, they've been roundly and internationally condemned. Civilian harm has been reduced by the prohibition on anti-personnel landmines and the global reduction in the use of cluster munitions. We've also seen many states, like the US and others, realize the policy advantages of ensuring the protection of civilians. Though here I'd just raise a word of caution, if I could, to note that it's IHL requires states to take all feasible precautions to ensure the protection of civilians. That is a legal obligation. It's not a policy position. I know I'm talking to the converted here. I know you guys know that, but I equally know that we need to regularly remind policymakers that it's the case. Okay. It's the reason I say that is that there's a sense in which a policy approach makes protection seem like an optional decision, which could be adjusted when the situation is no longer expedient. For example, in a high-tempo, near-peer conflict. That's not the ICRC reading of the law, and indeed it doesn't serve the object and the purpose of the law. The Geneva Conventions and IHL in general has also been the frame which has facilitated much of the work of the ICRC, from visiting detainees worldwide to accessing areas of conflict with the agreement of all parties to the fighting, so that we can deliver humanitarian assistance, and our work to identify the missing and the dead, to bring closure to families who may have lost loved ones in fighting. All of these roles are enshrined in the Geneva Conventions. Together, along with our other work, they've allowed us to provide crucial humanitarian assistance for conflict-affected populations all over the world. And that's another benefit that's come out of the Geneva Convention system, the IHL system that we have today. But none of that can be taken for granted. And I think it's great that within this room, we have a lot of young people, right? Because you are the people who need to go forward and defend what we've got. It's not for the old folks here, right? We're passing out. The future is with you people. The access I mentioned lets our teams on the ground help those affected. Yes, that's good, but it also lets them see the terrible humanitarian impact of the failure to comply with IHL. Whenever there's fighting, civilians and those who no longer fight, and thus should be protected, nevertheless are affected. What we see is the scope and suffering of those affected by conflict is enormously magnified when compliance with the law is weakened. We've spoken over these last few days of the balance between military necessity and humanity. That equation is at the heart of the intent of IHL, to protect those who don't or no longer fight. But when IHL is ignored or just selectively applied, or when the standard of application is allowed to drop, the impact that we see on the ground is horrific. So, for example, the law tells us to weigh the military advantage of an attack against the anticipated civilian harm, right? You all know that as a part of IHL. But what about the steady accumulation of multiple attacks, creating layer upon layer of infrastructure damage in an urban area? Should the calculus be based on each specific strike, or should it integrate the totality of the effects on infrastructure, including direct and indirect but foreseeable harm? Harm that can make entire cities uninhabitable and take years to reconstruct. Of course, the ICRC would argue for the latter, that you need to take into consideration the totality. But those trying to constrain the range of the law could stick to a highly restrictive reading. Now, lawyers can debate the interpretation of custom or black letter law, but at the end of the day, it's civilians that suffer, either in the moment of the attack or in the aftermath of the destruction that comes with it, when they no longer have access to essential services, when they are displaced because they simply can't live in a place without water, without healthcare, and so on. So the law embodies simple but powerful and universal protections which are common across cultures, and we need to interpret it as such. We've heard a lot today about the requirement for further interpretation. The heart of the law is very clearly about protecting civilians, and that should always frame those thoughts. So the protections that we recognise in the Geneva Conventions and IHL more broadly today enshrine, reflect and build on millennia of similar efforts in wars since antiquity. If we choose today to belittle those protections or to hide behind language that somehow obfuscates the role of the law, we risk damaging it in perpetuity. And again, I come to the younger people in the room, you're going to have to live with this. So if you weaken it today, it's going to be really difficult to defend it in the future. So it's on you to make sure that this goes forward. When we hear a situation described as in the grey zone, there's an implied assertion that somehow that's ungoverned space, an ungoverned situation. That's not the case. If there are attacks going on, IHL applies. We need to challenge that sort of weakening of the law. When we see wholesale destruction described as a series of precision attacks, we need to challenge that narrative and interrogate whether the law is being applied as it was meant to be, the intent of the law. When we see ICRC access to detainees to whom the law gives us access, when we see that similarly restricted, or our access to deliver life-saving humanitarian assistance, we need to challenge that in order to reinforce the need for compliance. And this is a global issue. We see it becoming an issue everywhere, and we need to push back on that. Of course, at the end of the day, the ICRC can and does argue for compliance, either in general public statements or in very specific and detailed confidential interventions which we have with states and with parties to the conflict. But we recognise we can't do that alone. There's been a lot of talk over these last couple of days about the role of the ICRC, but we cannot do this alone. We simply don't have that weight. That's why our president has regularly called for states. And remember, we had that discussion around IHL is law of states, by states, between states. Our president's called for states to make compliance a political priority, not only for their agents, but also amongst states as peers, with responsibility for the most widely ratified international law we have. States have that responsibility. States negotiate instruments that place limits on warfare. They accept to be legally bound by these instruments by ratifying them. They integrate IHL rules into their national legislation, policies, practices. It's states that conduct legal reviews to ensure new weapons, we've been speaking about new weapons, new means and methods of warfare are in conformity with IHL, the Article 36 business. It's states that ensure that their armed forces know the law, are trained in it, and are subject to a strong disciplinary system. Colonel Pettis spoke to some of this earlier on. It's states that put in place penal legislation and a judicial system that prosecutes the grave violations of IHL. Through bilateral, regional, multilateral collaboration, states are also able to ensure, or others, including their allies and partners, and think about the leverage that the US has with all of your allies and partners. You can help them to respect their IHL obligations. Looking ahead and looking into the future, your discussions have understandably raised the question of whether IHL is fit for purpose 75 years after the drafting of the current conventions. We in the ICRC, we're not complacent to that inquiry at all. In one sense, as a former military officer, I would argue, though, that warfare is perennial. The scenes I saw as Yugoslavia fell apart in the early 90s were reminiscent of the suffering that Thucydides described 2,500 years ago, or that Henri Dunant saw at Solferino, and that we still see today. What's changing is the speed and multi-domain scope of warfare and the tools available to fight it that we've discussed a little bit today. The conventions of 1949 were a development of their predecessors adapted to the lessons of the Second World War. We do not have a new set of devastating lessons to draw on, and we don't want to. So how can we make sure that we adapt to the new technologies and bring those into our thinking? We've spoken today about the application of autonomous weapon systems. Where is command responsibility in there? How do we maintain that element? How do we maintain the human control of these weapons? The ICRC has accepted that that is an area where we may need to develop more guidance. We also need to be very clear that and the application of IHL to cyber and information operations, IHL still applies. There is a general agreement that military operations conducted in cyberspace in situations of armed conflict are covered by IHL. And we need to be clear on what constitutes an attack in the cyber domain, similarly in the space domain. So I would just draw a couple of conclusions, if I may. IHL has protected people for 75 years. We can all be clear on that. And it's because of the work that people like you have done that's allowed it to be brought into military practice that's allowed that. But it can only continue to do so if compliance is maintained and the balance between military necessity and humanitarian impact is kept and maintained. Compliance is the key. The law will work if we make sure that the compliance is there. We need to track emerging technology, the use and effects of new weapons, and we might need to build on some of the framework that we've got. And we recognise that. But at the heart of it, the Geneva Conventions remains a useful frame for that commander in that situation that I described in my story to try to achieve the military necessity at the minimum possible humanitarian harm. And on that, I'd just like to say thank you very much to the team here. It's been an excellent couple of days from my perspective, and thank you all. Thanks a lot.
All right. What a terrific way to close. So while we send you on your way, please take one of the issues of our Journal of International Law that are on your tables as a souvenir. Thank you all for being a great audience. Thank you all the speakers for being terrific. Thank you, Journal of International Law people, for helping us organize this and publishing it. And everybody, safe travels. This concludes our conference.